Ladies and gentlemen and ladies and gents, Ray Charles in the background, and he's talking about what he can't stop doing. You know what? Donald Trump and Ray Charles had a lot in common because Donald Trump can't stop lying. No, don't do it. Don't you ever even think about it. Those of you who are on Donald Trump jock so much that you're sitting up there smelling Similac. Shut it up. Just shut it up right now. Obama lied. Clinton lied. Hey, even I lied. No, I don't. No, I don't lie. Okay, I apologize for him interrupting us. All right. Look, ladies and gentlemen, I do believe that Donald Trump is suffering from early onset menopause and early onset dementia. I can prove it. I guarantee you, I can prove that Donald Trump is suffering either from dementia and or Alzheimer's. See, when he first got elected, that idiot ain't forgotten nothing. Ain't never had to correct nothing he said. But all of a sudden, when he says no, he means no further questions. And when he says would, he means wouldn't. He's a politician now, because that's what politicians do. And by the way, his tweets, I told you this was coming, we're going to start being written by attorneys. The White House staff. Why? Because he's got to look more presidential. And I want you to wait about 3 more months and notice how his personality will change. It happens to every single person they put in office. Now, my opinion, I don't give my opinion that often, you guys know this. So this is not substantiated. All I know is that every single person who has become president, they've always changed. Their personality has changed, and this ain't no growth changing. This is a complete personality turnaround from who they were campaigning to who they were in the office. And this is not, like somebody gets, drunk with power. This is not that type of change. This is a complete personality change, which is why you have some people saying certain people are these things they want to call clones. I'm not saying nobody's no clone. Look, they do not have the technology to reproduce the human brain. They cannot create such a computer. If they could, ladies and gentlemen, we would be traveling at least 8,000 times light speed. Oh, by the way, scientists are saying that you can't travel faster than the speed of light. That's a lie. They think that because they've done a little bit of, calculations that they know the entire universe and they know how physics works throughout the universe. No, physics works differently throughout the universe. Now, I can prove this. This is simple. Remember, they believe, no proof, but they believe that there are these things called black holes. And then they have theoretically determined what a black hole would do, what its powers are, blah, blah, blah. They have no clue. They're just guessing with their limited knowledge. Let's get back to this. Well, what I meant to say was, and when I said that, I meant this. Go back and look how that man has never corrected a single statement that he's ever made. If he's made a statement, he's always stood by it and said, yes, I said that. Sorry, there were some things about him I liked. And the fact is, I like the fact that the idiot spoke his mind. Even though if he didn't have one, he still spoke what he didn't have. So he spoke his mind. He's not doing that anymore. Do you notice that? Now, oh, by the way, the Russia thing is a distraction, people. The Russia thing is a distraction. Why is the Russia thing a distraction? Because just prior to him going off to Russia, we found out, well, first of all, the National Farming Housing Act. You remember that act that they did and it was attached to that so-called tax cut? Well, the federal courts have ruled it unconstitutional. Said it was a violation of the separation of powers clause. Okay, people, distraction. Who cares about Russia? All he was doing was talking with Vladimir Putin. They could talk over the phone. So what was the problem with him going to Russia and talking with another world leader? Well, the Democrats said and the Republicans are saying that was detestable. Really? Yeah, he shouldn't have gone over there and talked to them. Really? Why? Well, because it was detestable. It was the most detestable thing a president has ever done. The most detestable thing a president has ever done? Let me see. I can think of some detestable things presidents have done, such as permitted the hanging of slaves, permitted slavery into the United States, killed the so-called Indians, hunted down Geronimo and his people, slaved the women and children. I mean, we can go on and on and on about detestable things presidents have done, and you're saying Donald Trump speaking with Vladimir Putin is worse than that? What about the Jim Crow era, where the president stood back, kept his mouth shut, and allowed it to go on? What about the lynchings in Mississippi? What about the segregation of the churches and the schools? Huh? What about the fact that the courts are filled with minorities being placed in jail? What about the fact that the disparaging charges that a person charged with possession of cocaine and a person charged with the possession of crack or methamphetamine receives harsher sentence than others? What about that? What about the fact that the president is allowing people to be treated as if they are minors when they are full-fledged adults? And you're saying him talking to Vladimir Putin, who I used to admire, but he's an idiot himself because he has decided that people are extremists. The most peaceful people in the world are extremists. Yeah, that's right. Russia has declared Jehovah's Witnesses to be an extremist group. They have did what the United States do to sovereign citizens. Russia has declared the Jehovah's Witnesses in Russia to be likened to sovereign citizens, terrorists. Now, I'm sorry, the people who knock on your door wanting to share a scripture with you, Russia says are terrorists for doing that. Now, if people wanted to say, hey, because, and you know, they're talking about what they're doing to religious groups throughout the world, they won't mention the word Jehovah's Witness. But when they talked about Russia and its failure to recognize religion, they're talking about Jehovah's Witnesses, but they won't mention the name Jehovah's Witness. You know, that group that has won more Supreme Court cases than any other group in the history of the United States. So they won't mention that because they don't want you all to see or to have compassion or to have sympathy for that group. What they want is for you all to focus on a different angle. So, ladies and gentlemen, it is a distraction. And you all have to be able to see that. Now, look, the reason why I'm showing you all this, and there's a reason. I'm not just letting this thing be in the background on my screen because I don't feel like doing nothing else. Oh, was that wait. Bon Ivory. I believe this is, no, I'm sorry. Think. I apologize, ladies and gentlemen, because this song sounds a lot like, but there it is. Think. So I apologize. I didn't know who Fink was, but now I know who Fink is. So the first time I've listened to Fink, you guys have seen this video, haven't y'all? I know you guys have seen this video. I like this video. Okay. I think this video alright. and judicial proceedings, or copies thereof, copies of the records, so authenticated and attested, shall have the same full faith and credit in every court of the United States. Case, December 29th.
December 29th. 1967. That was a good year.
Anyway, ladies and gentlemen and ladies, this is SMUC, Shawmut Bank.
National Shawmut? Oh, is that a holiday? Is that like Leprechaun Day? National Shawmut? They must be Scottish.
Anyway, National Shawmut Bank versus Victor L. Jones, Supreme Court of New Hampshire. So why is the Supreme Court referring to this case that was heard more than 50 years ago, when they enacted the new state law? Why are they referring to this case? Well, ladies and gentlemen, hold on. They're going to tell you. Since Weaver purchased for personal, family, or household purposes, pay attention, when you make a purchase for personal, family, or household purposes, it is classified as consumer goods. 9-109 of the Uniform Commercial Code. That's why it's a separation, people. This is the UCC, 9-109, 9-306, 9-307. In the case of buyer's goods, that's 9-307, does provide otherwise in certain instances. Pay attention. The plaintiff's security interest was perfected by filing a financial statement with the clerk of Hampton, where Weaver resides. Ladies and gentlemen, you don't have to file your UCC with the clerk, but here the court says you better file your UCC. You have a property, you file your UCC with the county clerk. You have a car, you perfect your security interest the same way as Weaver did.
Oh my God, this is probably the greatest video he ever did! Oh Lord, this is the greatest video! Can you say that again? Because I think you just said something profound.
Ladies and gentlemen, you have a car, you have a home, you have any personal property that may even be considered valuable. You take your personal property, you do a UCC1, you do a UCC addendum, and you do a UCC3, which is called assignment. I'm not going to tell you how to do those. That's not my job. If you want somebody to tell you how to do that,
Oh, you have 10 more days?
well, no, they actually have 8 more days because this is the 21st, the first day of summer. So, no, they have 8 more days because on the 30th, it's over with, said, and done.
It's over and done, but the heartache lives on inside. Huh? And who's the one you're clinging to instead of me tonight?
I'm sorry. Oh, you guys don't know? Too much, too little, too late. That was that song. Anyway, Ladies and gentlemen, you know what? To this day, nobody has called, asked for a consult about the UCC, about how to properly fill out a UCC. Anyway, that's actually amazing because I've actually told people that it was necessary. So let me because
Oh, that's just so great. Could you please explain that again?
because I promised that I was going to explain it again. Let me explain it again. Hey. I don't know who this is, but let me put them on pause. Who y'all be? Oh, this is Ray LaMontague. I don't know LaMontague, but I do know this song because I played it before. Hey, Ray, y'all hold on, okay? Hold on. We're going to get back to you. Hey, y'all give Ray a good hand. Thank you, Ray. All right, ladies and gentlemen, let me explain. Look, I had a young lady who I'm helping with a case. She wrote me back and she said, I got this from the court today. They say they're dismissing the appeal. Okay, they say they're dismissing the appeal. So I wrote it back and I said, what did I tell you all about trying to tell me what the court is saying? I said, if I'm working with you, you send me the document. I will read it and determine what the court is saying. You see, look, ladies and gentlemen, when you read a court case, you don't know what they're saying because you can't read their language. This is not English, people. This is legalese. Nothing in this is English. It's only designed to look like English. That's why I can highlight that phrase in front of you. I can highlight that phrase for one reason only, because I recognize that it's not English. I recognize that all of this is legalese because this is a Supreme Court talking. They're not going to put this in English. But hold on. I gave her a piece of my mind because I told her in the past she was always apologizing. Well, I'm sorry if I'm bothering you, and I'm sorry this and I'm sorry that. And so I told her straight up, I said, hey, if you are bothering me, I promise you, I will let you know. If you are getting on my nerves, I promise you, without hesitation, I will let you know. Ladies and gentlemen, I had to tear up one of my emails to her because I was letting her know, and I didn't even, Lord, I was offended by the second one, so I had to tear that junk up, destroy it, delete it, trash it. Here's the thing. I called her up the next morning, and I told her, I said, ever since you sent me that, I've been up. I haven't had any sleep. I said, so I produced this. You will send this to the court. I said, but I give you my word, if you do that again, I will not help you anymore. Period. There will be no, well, I don't care. Well, I'm sorry, won't work. Well, I apologize, won't work. Well, no, won't work. Doesn't matter what you say. That was our conversation. Then I reminded her, I told you when you got on my last nerve, I would let you know. She said, yes. I said, well, I'm letting you know. I don't have time, people. I'm not going to tiptoe. I don't like eggshells. So I'm not going to tiptoe around your feelings when it comes to me helping you and then you wanting me to feel your pain. You wanting me to feel what you feel. The reason why she emailed me that and put that comment in is because she thought it was a bad thing. Let me tell you what the court dismissed. When the court dismissed it, it was not, pay attention, pay attention, pay attention. I want you, pay attention. Let me tell you what the court was saying because many of you are not going to understand. If you just listen to the title of our email that the court dismissed the appeal, the court didn't dismiss the appeal. The court was saying that it was going by the record. Not it was going by the documents that she put into the record, the documents that were filed on the record. No, it was actually going by the record of what was spoken in court. It was ignoring the documents that were placed into the record. Remember we told you to stand on your documents? You shouldn't be talking in court? Well, that's what the court is doing. They're only going by the record of the stenographer. Challenge that record. Challenge that record, people. Do an audio You have the right to demand that the proceedings be audio recorded. There is no law requiring that the proceedings be stenographed. Every court has a right, gives you the right to have the proceedings recorded. That includes audio recording. People, I do it in every case I enter. Every case I enter on my own behalf, if I'm doing something for you, no, I'm not going to do that for you. I do that for my benefit. I'm not going to do that for your benefit.
But you're trying to help people. Shouldn't you do that for them too?
No, because when I'm doing a case for me, I'm doing it because I understand why I wanted audio recording. You, if you just ask, well, I wanted audio recording. Why do you want audio recording?
Well, because somebody did a video and they said I should ask for audio recording.
All right, denied. Okay. Ladies and gentlemen, the reason why you wanted audio recorded is because audio recordings does not allow the stenographer to say inaudible. Pay attention. Does not allow the stenographer to imagine what was being said. When you look at a stenographer's rendition of how things are done, you see how they put it in such paragraphs? Remember, they put it in paragraphs. Why do they put it in paragraphs and then they put the name of the person who's speaking? Why do they do that? They do that because they're trying to sway the intent, the context. That's why they do that. So you demand audio recording. Okay? Just that simple. And you demand audio recording because it is your right. I don't have to explain to you why I'm exercising a right, just that I'm exercising a right. Now, if you have a problem with that, you need to go back home. You need to put your finger in your mouth, the thumb. I'm sorry, I said finger. You need to put your thumb in your mouth and you need to go and tell your mama what your concerns are. But for right now, this is a judicial matter. I don't have time to deal with your so-called whinings, Your Honor, if you would excuse me. Let him get upset. No, 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 don't y'all do this. I'm telling you what I would do because that's what I would say to him. And if he got upset, I'm sorry about your temper tantrum, sir or miss, but I'm not here to be at odds with you. But if you want a challenge, go right ahead and step outside the scope of your oath, the capacity for what you're sitting. You took an oath as an officer of this court. So as an officer of this court, you're under oath. So go ahead and get mad and violate that oath. Go ahead and scream and yell and get angry and violate that oath. Go ahead and act with personal intent and violate that oath. They don't talk to me the way they talk to you. You can't do what I do. You can't speak to them the way I speak to them. I've already done videos recording. Pay attention. Remember, my hearings are recorded. This is not the first time I'm telling you guys about having your hearings recorded, but I've already done videos placing the recorded hearings on where you hear judges telling me, if you say one more word, I will hold you in contempt. And I simply say, oh, excuse me. What I meant to say was, and I keep talking. And there's no contempt charge. Why? Because again, you can't do what I do.
Do I do what you do when I do my love to you? How?
I'm sorry, Stevie Wonder. All right, let's get back to this, ladies and gentlemen. This is the Supreme Court. This is the Grimes that the Supreme Court was referring to when it was referring to Grimes. Hold on 1 second. 1 second, people. Ladies and gentlemen, that was more than a second. That was more like 8 minutes. I've had some time to think about how I'm going to present this to you. I've had some people complain about how I do videos. And you all know how I feel about them. Those special, ordained, reverend morons. Okay, understand. This statement right here, non-consumer, that it's not non-consumer goods. That it is used for personal, family, or household purposes. It is consumer goods. All of your property should have a statement saying that you purchased it for personal, family, or household purposes, consumer goods. You have a credit card, UCC that mother. I'm sorry, apologize. Ladies and gentlemen, you know all these contracts you've been signing with people, all of these accounts you've been setting up, your birth certificate, you were proper to register your security interests. The filing of a UCC financing statement, pay attention, since Weaver purchased for personal, family, or household purposes the DART, an automobile, for those of you who are not old enough to know what a DART was. Oh, I thought that was one of those things you shoo, bullseye, right into the board. I play darts. No, that's darts, not dart. This is the singular, not the plural vernacular. Okay? The DART is classified as a consumer good. Are you a consumer? Did you know that you have consumer rights? That there are consumer rights laws? That you should be notifying them as a consumer, I have rights. And you should be telling that to the court when you talk about your mortgage. This was purchased for personal, family, and household purposes. It's a consumer good. And I perfected my security interest. So that don't mean nothing. We're here because of the deed of trust. This ain't got nothing to do with what you're purchasing. Yes, it does. It has everything to do with that because that which precedes what came last takes precedent. Aha! Foundation, moron. Sorry. Ladies and gentlemen, may I have your attention? The plaintiff's security interest was perfected by filing a Uniform Commercial Code Financing 1 statement. See, they didn't put the UCC financing and they didn't put one statement there, but this is what this is called. And if you read the definitions for the Uniform Commercial Code, it is for the perfecting of a security interest. Okay? That's what this case is about. But if you read it, you would not recognize that. Oh, yes, I would. I saw that. Shut it up. That's why I don't let people tell me what a case is saying. Now, look, hold on. You have to file your Uniform Financing 1 statement in the county where you reside. Pay attention. Now, when I say you have to do that, I would also suggest you file that on the national form, and you do that in your birth state, respecting your birth certificate. Nobody can stop you from doing that. You can attach your birth certificate or even a copy of the birth certificate. It doesn't even have to be a certified copy. Pay attention, people. It doesn't have to be a certified copy. You take a copy of your birth certificate, do it on a UCC, file it with the county recorder. In Los Angeles, that's about $60 to file a UCC because they recognize the power that it has. Gain control over your security held in your minor account. Okay, hold on. Hold on. We are, as of now, the UCCs have been filed, and now the ones for SATCOM, we filed a different UCC for different purposes because, again, we are creating securities for our members, but they will take their certificate of live birth and do a UCC. They will follow the same format as the one that was filed on their behalf. It will be a couple of weeks before we can get the numbers for everybody. This is not something you have to rush and do. Russian? I'm not Russian. That's Vladimir Putin. Anyway, shut up. Ladies and gentlemen, this is not something we promised we would do. We said we would help people gain control of the securities held in their account. We are more interested in creating a security for you, letting you take care of that aspect of documenting your security interest, because associated with your security interest is your affidavit. See, what we do is we don't file it on the county record. We filed it on the Secretary of State record. We'll let our members file it on the county record for the county for which they're associated. Again, we are doing this on a broader scale for our people. All right. If you don't understand, sorry, you're going to have to go back and listen to that portion of this video, which was the last 10 minutes. Now, let me finish explaining this case to you. This is the code 9-401. I'm not going to take you to the code. I'm pointing the code out to you in the actual case, because sometimes, and most people don't know this, the court tells you exactly how to do something. Okay? This is about perfecting a security interest. Now pay attention. Now pay attention, people. Why did Mr. Weaver do a UCC? Why did he do a UCC? He was just purchasing a car. Why in the world would he do it? Hey, answer the question, people. Because when you purchase a car, when you purchase your house, do you go and file a UCC? Of course you don't. It says, and continues when the collateral is sold without its consent, as was the case here, unless Article 9 provides otherwise. Then Article 9-306. In the case of buyer's goods, Article 9-307 does provide otherwise. Hold on, here's the otherwise. Pay attention, because it says, unless Article 9 provides otherwise, the court is letting you know what the otherwise was. A buyer in the ordinary course of business, subsection 9, section 1-201, other than a person buying farm products from a person engaged in farming operation. Okay, hold on. We don't care about this. Ignore that. So, a buyer in the ordinary course of business takes free of a security interest created by his seller, even though the security interest is perfected and even though the buyer knows it exists. Basically, this is the exception. If you perfected a security interest on something and then you sold it to someone else, the security interest does not transfer to the new person unless you do an amendment of that Uniform Commercial Code filing. Other than that, when the individual buys it from you, you can't come back and say, oh no, I sold that to you, but I still have a security interest in it, okay? It says, look, even though the security interest is perfected and even though the buyer knows that it exists, it doesn't matter. It's negated. Hold on, people. You done purchased the house. I would even, now I'm not telling you this will work. I'm telling you this is how my mind thinks. I would even take proof that you did a bill of exchange, a money order, or promissory note on your home. Attach that to your UCC Financing 1 statement and file that on a county record. Perfect your security interest. Let them tell you that it's not a perfected security interest. Let them go into court and tell that. There's something we're going to tell y'all at the end of this video that you're going to see we're going to start offering as a service. Well, I'm going to offer it as a service, but I've given the idea to SATCOM. So SATCOM has a proprietary arrangement agreement. In other words, when I donate an idea to SATCOM as a means of helping people, it becomes SATCOM. So I can't use it for my own personal benefit, and I can't use it for someone else's personal benefit. It becomes SATCOM. They have a prioritizing, it's proprietary. Prioritizing is the word that's been used because I have Verizon. They told me I'm not prioritized. Anyway, and so I've given that idea to them. Now, mind you, what I needed to explain to you, I just explained. So now we're going to go back. I had to make sure I clicked on the right one because I have a video I'm watching. Okay. Now we letting Ray continue. Okay. Let's get on here. Since the defendant purchased in good faith without knowledge that the sale to him was in violation of the security interest of another and bought in ordinary course from a person in business of selling automobiles, he was a buyer in the ordinary course of business. A buyer in the ordinary course of business is where that's coming from. Pay attention. That's why it is, pay attention in quotation marks, letting you know that this is where it's coming from. They also tell you one that do deal one. They deny one that do deal one. That's what they did that for. However, that's right, that word conjunction, junction, what your function? Okay, that's what however is. It's a conjunction. What's a conjunction? Well, it's a word that combines two separate sentences, but also demonstrates a different point. So it's like using the word and or but. But that's a funny word, but. My mama said I got a big old butt. You got a big old butt too, Miss Crabtree. Anyway, let's continue, shall we? However, Article 9, Section 307 permits him to take free only of a security interest created by his seller. The security interest of the plaintiff was not created by Hanson Rock Incorporated, the defendant's seller, but by Whitworth Mortar Company Incorporated. The defendant, therefore, does not take free of the plaintiff's security interest under this section. Neither does he take free the security interest by reason of the provisions of 9, Section 307, related to consumer goods, even if he purchased of its own personal, family, and household purposes, a fact not agreed upon, because prior to the purchase, the secured party filed a financing statement. Pay attention, people. I'm sorry, I heard this song come on, and y'all know Purple Rain. Y'all know what that song does to me. If only people understood what he was actually saying in this song. I've not heard, well, he knows, but I've not heard one person say exactly what he meant by purple rain. Why was it called purple rain? Why didn't he call it blue rain? Why didn't he call it green rain? People think he's talking about emotion because they saw the video. Please. They think he's talking about, somebody feeling blue, going through difficult times. Ladies and gentlemen, the color purple is symbolic. Rain is symbolic. Okay? Then he talks about seeing somebody laughing in their purple rain. He talks about never wanted to be a weekend lover and people thought he was talking about sex. I only wanted to be some kind of friend. See, I just wish people knew what he was talking about. I'm not going to tell you guys what he's talking about. You just have to go do your research on what purple means and what rain means, what it symbolizes. Okay? And then he says, let me guide you to your purple rain. Talks about a friendship ending. If only you knew how purple rain can end many of friendships. All right, that's it. Don't guess, don't email me, don't text me, don't write me, don't call me, don't Skype me, don't female Facebook me, don't none of that. I don't want to hear it because you're not going to get it right anyway. You have to understand what he was going through when he wrote this album. That's why all the songs, when doves cry, they all talk about the same central subject, but nobody paid attention to that. I did. Anyway, talks about times are changing. Didn't you hear him? He just told y'all. He's not talking about no stupid relationship with no female. Talk about reaching out for something new and time being changing. That means you too. Say you want a leader? I told you. you better come and let me guide you to your purple rain. Okay, so like I said, people didn't get this song. Even though everybody and their grandmama can sing it, they didn't get it. I got it. Anyway, then you need to go ahead and hold on to it. Now, so that you guys understand what's happening here, it's saying that if you're not the original owner of the property, if you're not the original purchaser of the property, then you cannot supersede someone else's financing one statement. However, if you purchase a property from the original owner, which many of you do when you purchase the property originally, okay, you can go and place your security interest on the record. But if you've lost that property and someone else has purchased the property and there was not a security interest placed on the property, then you cannot put your financing one statement ahead of the person who put theirs on first. That's where the first in line, first in time comes. However, if you are in your house now, you are current on all of your payments. You are the owner of the house. You're not the tenant. Matter of fact, somebody just brought to my attention that their deed of trust says that they become tenant when they miss a payment and are in default. Upon that point, they become a tenant, a renter, which allows them to be foreclosed on. Okay, now let's go here. Supreme Court of New Hampshire is telling you this. These are the only two provisions in Article 9 under which a buyer of goods can claim to take free of a security interest where a sale, exchange, or other disposition of the collateral was without the consent of the secured party. The defendant does not benefit from either. Article 9, Section 306 gives the court no leeway to create any other exception to its dictates, and no custom, usage, or agreement has been brought to our attention which would permit us to do so. Pay attention, ladies and gentlemen. You can use this case, okay? Pay attention. You can use this section when having to explain this. The only thing you will take out, I want you to hold on to this, you will take out the RSA 982A. You'll take that section out. That doesn't belong here. You will continue to keep 1-102. You will continue to keep 9-306. You see, this is for New Hampshire, revised statutes, annotated. Okay, that's what that stands for. Again, that's because I do this. Okay, and have been doing this for a while. I've never read their statute to see that when you go to Kentucky, when you go to New Hampshire, that RSA stands for Revised Statutes Annotated. I know for a fact that you just go ahead and check. Okay. Now, the defendant contends that Section 2403 provides an escape for the plaintiff's security interest when it provides a person with voidable title has power to transfer a good title to a good faith purchase of value. The contention has two answers. Article 9-306 provides for continuance of the security interest except when this article provides otherwise, thereby limiting any exception to this contained in Article 9. Article 2-403 itself provides that the rights of a lien creditor are governed by the articles on secured transactions. 2-402, which provides nothing in this article shall be deemed to impair the rights of a creditor of a seller under the provisions of this article of secured transactions. It is clear, therefore, that security interest in the case of a sale without the consent was to be impaired only as provided by Article 9 and is unaffected by Article 2-402. Our answer to question 1 is in the affirmative and to question 2 is in the negative. Remanded. All concurred. This was a unanimous decision. So let me show you why this was so important. Hold on. This is the New Hampshire House Bill 1778, which actually passed in March of this year. This was the original legislation, the original bill, but now it has been passed. So let's find out again, because that's where we be. Touchscreen. It's touchscreen, y'all. Okay. This is the New Hampshire law.
Why you want to talk about me? Why?
Y'all know y'all like this song.
Tell me.
New Hampshire, state of the year of our Lord, 2018. Okay, an act relative to the registration of commercial vehicles and operators / driver's license. Have you heard the phrase? Operating a motor vehicle? Okay, to operate a motor vehicle, you need a driver's license. Ladies and gentlemen, you don't ever want to tell them you're operating. That's why you hear people using the phrase travel. Now, I don't care about the word travel. When I use the word driving, I use the word driving. Oh, and by the way, the reason why I know I didn't have to read this about an operator's license. I already knew, because I told you I took the test to become a bus driver and a commercial truck driver. I've had in a particular state, I was the first person, the youngest person, to receive their CDL in that state's history, because they had just come up with the CDL program. I had just turned 21, and you had to be 21. So I turned 21 that month, the same month I got my certificate. Told you, in my life, I've either been the first to do something or amongst the first to do something. That's been my entire life. So I'm kind of proud of that, y'all. But what you all don't know is that, and I got to give Maxine her credit. Maxine Waters taught us to, when you go to a job, the first thing you do is ask them for a copy of their policies and procedures. She literally told us this. Now, I remember when I first started being around Maxine knew my mother. I knew her. Hello, hi, goodbye. That's all I knew about her. But she had this school that she set up. You know how everybody's doing these schools? These so-called, what do you call these stupid schools these people are doing? Where they send them kids to these, I forgot the name of them schools. I can't think of them schools right now where everybody's setting up a school. Well, Maxine Waters did this in 1983, people. She had just started the class and asked my mother to allow me and my sister, not my other brothers and sisters, just me and my sister, to be a part of this class. And she had to get my father's permission, because this was after school, and my father, after school, we had things we did after school, and he needed to make sure that this was not going to interfere. See, when we say we had things we did after school, that's not every day. See, Jehovah's Witnesses have meetings during the week. So at that time, we had 2 meetings during the week, which usually didn't start until 6 p.m. Or, one of them started at, both of them started at 6, honestly. One of them happened on Tuesday, the other one happened on Thursday. He wanted to make sure that whatever they were doing would not interfere with our going to our book study and our theocratic ministry school and service meeting. And she assured him it wouldn't. He also needed to make sure of what she was going to be teaching us, because he didn't want her filling our head. He didn't know what she was teaching, so he didn't want nobody filling our heads with stuff that would contradict, that would challenge, that would cause us to go a different direction. Now, people say, well, he didn't want you to be unbrainwashed. No, what he didn't want was for people to sit up there and convince us that something was true when it was not. See, kids are very influenceable. So you basically tell a kid, oh no, God doesn't exist. And the kid will start to think that he doesn't. Not know that he doesn't, because people make statements to kids all the time and kids believe it. You don't believe me? Just like many of you believe so much junk that you hear on the internet. You listen to a video, you listen to what somebody tells you. Pay attention. I'm showing you the law. That's been my habit because that's what I was taught by my father. Okay? He told me to back up everything I say, prove what I say. Then another Jehovah's Witness showed me 1 Thessalonians 5:21. I have never forgotten that. Made me remember that scripture. It says, make sure of all things, hold fast to that which is true or which is fine, as the King James Version says. Make sure of all things. Ladies and gentlemen, that's my rule. You don't just get to come tell me something. This has been me all my life. I prove what I say. So again, Chief Justice Grimes, he said, pay attention, he confirmed that when an individual purchases an automobile, it is purchased for household goods, consumer goods, and not for commercial use or profitable gain. Isn't that what the case just said? Further, the courts have found that the corporate public servants have ignored their accountability as mandated in Article 8, New Hampshire Bill of Rights, and have by their silence and failure to fully inform the sovereign people of the consequences arising from the corporate offer to contract is deemed silence, silent deception, and inducement to fraud. This is why that case was so important, because you don't need the case, people. You need to understand the Uniform Commercial Code, Article 9, Section 109 says that my automobile, because I purchased it for private, personal use. Hold on. Because what is this? Somebody, anyway. Bye, Brown, y'all. That poor man. Oh, by the way, when he made this song, he believed the words. If he hadn't done that, things probably would have been a lot better. Anyway, you got a traffic ticket? Say, I'm sorry, I wasn't driving commercially. My car has not been purchased for commercial business. My car was purchased for personal, family, household purposes and is classified as consumer goods according to UCC Article 9, Section 109. Okay, that's how you handle traffic tickets, people. Unless you got evidence to the contrary, Your Honor. Then why are we here? Okay, well then, since we are here and you had no proof that my automobile was purchased for commercial use, I need to be reimbursed for my time and my expense. Oh, no. You're getting paid to be here. I'm not. I need to be reimbursed for my expense. Or I will be filing an appeal. And I'll be filing a claim, not a complaint, a claim against you for failing to carry out your fiduciary duty. Just that simple. Can y'all handle that? Can y'all handle this? All right, look, ladies and gentlemen, you know what the biggest problem is? This information has been there the whole time. They didn't just invent this. This information has been there the whole time. Okay, give me 1 second. We're going to play this song. We know y'all want to hear it, but hold on. We're going to play that song in a minute, but what I want to do is I want to play this. This is a motion for reconsideration request. Demand for judgment demanded and judgment presentment to vacate decision, judgment, ruling. What is that? Ruling, order, determination, and or blah, blah, blah. The denial of due process. To vacate the denial of due process. Basically, ladies and gentlemen, this is a motion to vacate and reconsider in one. This is if you've lost a case. Pay attention, people. If you have lost a case, that case was lost 3 years ago, 8 years ago, 15 years ago, and it deals with a mortgage. Don't say I ain't done nothing for you guys. This is the understanding. You do a petition for reconsideration. You bring up the issues, not all of the issues, just the main issues. that you brought up in your case originally. Now, see, what happens is people are getting personal. They're talking about things that have nothing to do with the judge hearing your case, reconsidering. You have to bring up facts, conclusions of law. So you bring up statutes and the Bill of Rights. Bill of Rights? Why would I bring up the Bill of Rights? Well, listen here, you ignorant mother. Do you see this? The courts have found that the corporate public servants have ignored their accountability as mandated in the Bill of Rights. You bring up the Bill of Rights because the Bill of Rights is what the law refers to as secured rights. If the right is secured, they cannot take it away from you by force or otherwise. So the right to due process is always your right. You don't have to beg for it or ask for it. Ladies and gentlemen, you don't want to reserve your rights. Well, you do. You're going to reserve, you're going to retain, and you're going to exercise your rights. Okay? And see, people have been reserving their rights, but they haven't been exercising them. Ladies and gentlemen, if you don't get no exercise, then you're going to be unhealthy. So if you're not exercising your rights are going to end up being unhealthy. Hold on, let's go ahead and play this, okay? So y'all can hear. Zira, we listen to you, but let's go to Kate. Okay, we're going to listen to Kate this time, okay, y'all? This is Natural Reader. Now this is 11. Yeah, I think this is 11. Well, it doesn't matter. This Natural Reader either 14 or 11. I think this might be 14. I think this might be 14. Hold on. 14, not 14. 14. This might be 14. 14. Not going to find it that way. Let's see. We'll go here. About Us. 2011. This is 2011. If you get 2011, that's serial number right there. So you're just going to have to, I can't make it larger. Okay, so you're just going to have to do that. That's serial number for 2011. Just copy that, download 2011, copy it. There you go. But it should come with serial number. Okay, real simple. That's what I had to figure out, that we get all these programs and they tell us update this and update that, and it's been updated and updated. Ladies and gentlemen, unless the update comes with some considerable changes, don't do the update. Stick with the original version. Ladies and gentlemen, oh, no. I don't want to open. What I wanted to do, I wanted to show you the different items. I wanted to show you the different things this does. It even does PDFs. Okay, so you can even put a PDF in here and it'll read the PDF. But let's do this, okay? Ready, set. Hey, come on now.
Reconsideration requested. 1. Reviewing the court's latest rendition of what it purports the law is by way of an order, we are left with several perplexing questions, and so we place these before the court in all due respect.
Her voice is choppy. Kate, I knew you were going to give me a problem. I'm going with Dave, Kate. So let's go back to the beginning. We started from the bottom, now we made it to the top.
Reconsideration requested. 1. Reviewing the court's latest rendition of what it purports the law is by way of an order, we are left with several perplexing questions, and so we place these before the court in all due respect. 2. According to the court, a party does not have the right to question the jurisdiction of the court. Is this correct? 3. That jurisdiction may only be challenged by a party who is not an alleged sovereign citizen. Is this the correct understanding? 4. That even if jurisdiction is challenged, an actual case law from the several federal district courts, the federal appellate courts, and the Supreme Court of the United States is inadmissible to support such a challenge. Is this the view of this court? 5. That the law has not defined what a quote-unquote sovereign citizen is, but it does define what the sovereign people of the state is, as has been confirmed by Chief Justice Grimes in 108 NH 386. If there has not been an evidentiary hearing, how could one be so labeled, and denied as well as deprived of rights? 6. Is it the opinion of the court that these so-called sovereign citizens possess no rights, are to be denied access to the courts, or to be discriminated against by the courts, or to be denied due process and equal protection of laws, and under what provision of the Constitution is this court purporting to act when making such a determination? 2. Access to information. 7. According to this court, a party may not utilize the internet in researching case law, is this correct? 8. According to this court, the case law utilized in the memorandum of law was inadmissible because it was not from published cases, is this not correct? 9. According
So that you guys will understand what's being said here, the court said, because I put in the jurisdiction case law as a memorandum of law, the court said that the person copied and pasted the law. They never said that the use of the law was inadmissible, or that the law they said that, well, the laws don't even apply to this case, but they never specified which one didn't apply. Because we were saying once jurisdiction is challenged, it must be proved. And jurisdiction, once challenged, must be proved on the record. That once jurisdiction is challenged, the court is prohibited from moving one step further until all jurisdictional facts have been placed on the record. The court said you copied and pasted that from the internet. So I don't care if I got it from my 5-year-old grandson. That's besides the point, you ignorant mother. See, that's what I'm saying to them. So I'm saying, are you saying that people can't get anything from the internet? So watch the logic in number 9.
to this court, only the court can utilize the internet for acquiring information, such as Westlaw and or Pacer. Is this the correct understanding?
They get to use Pacer.
10. According to this court, are we to understand that any information on the internet is inadmissible in every case? 11. It appears that this court did not answer any of the questions posed and or the challenges placed before it. The issue is not whether or not one copied and pasted from the internet, it is whether or not a party has a right to petition the court, to petition the government, to have their grievable issues redressed. Is this not the issue we placed before the court in the first instance? 12. And so that the record forever remains clear, documented, and established, each of the presentments presented this court have been originally produced by a competent non-attorney, who utilized voice recognition software to produce. So this court, acting under its presumptions, failed to produce any preponderance of evidence that would sustain its claim and or assumption that someone copied and pasted a presentment. But the court is here to shift the subject. Through its officers it wants to change the narrative, create a different path than the one presented, and we object to that. Not a single question placed before this court has been answered to this present day. That's intentional. This court is deliberately denying us the right to access the court, and to inquire as to the nature of these proceedings, and we object. 13. It appears the court is saying we did not have the right to challenge the recommendations of an officer whom we objected to from the onset. Now, despite what this court may think, despite what this court may say, we have the right to challenge a magistrate's assignment to this matter. That is a right that is secured by the Constitution and Article 3. This court is subjecting us to involuntary servitude, and we object. 14. You have forced us into your jurisdiction without our consent. This is a violation of our right to be free from involuntary servitude. 15. We have provided proof that if you are going to subject us to anything, it must be with our consent, since slavery has been declared illegal in the United States and the United States of America. See the Northwest Ordinance. 16. We have told this court that it engages in commercial business, that it does not represent the sovereign capacity of government, that this court does not represent the judicial branch of government as ordained by the Constitution, and thus because we have placed such on the record, that means that there is a conflict of jurisdiction, wherever the place the filing and copying and pasting information is permissible because attorneys do it, which means we have the right to do it. It is an elementary rule of pleading, that a plea to the jurisdiction is the first step in the order of pleading, and that any other or additional plea which refers to the court, any additional proof and or acknowledgement, other question, is a tacit admission that the court has the right, jurisdiction, to judge in the cause, i.e. subject matter jurisdiction, and is a waiver of all exceptions, i.e. acquiescence, whereby no challenges can be allowed respecting to the jurisdiction. Gertie v. Logan, 6, Bush Key 8. Whenever it appears upon the record that the court has no jurisdiction, i.e. in want of jurisdiction, nothing which the parties may do or omit to do will give it, that is, jurisdiction to the court, but where want of jurisdiction may exist consistently with the record, fingerprints, presumptions, assumptions, photographs, affidavits, documents, statements, a plea to the action, either entered by the court or by counsel/attorney or by a party, is a waiver of any exception to the jurisdiction, i.e. the party waived his rights and submits to the jurisdiction of the court. Lawrence v. Bassett, 5 Allen 140. 17. So again we remind this body that ignorance of the law is no excuse, and that because ignorance of the law is no excuse, we don't have to place case law, statute, ordinance, regulations, or any other form of authority before this body. The judicial officers of this court are said to be students of law, learned professionals, admission ed men, and as such this body should be more than aware that each of the presentments presented before it were not copied and pasted. The information contained in the instruments were based on affidavit format. B. That I permitted a party to produce the presentments before this court, which is my right to seek help from other competent non-attorneys to help me with my standing before the court. We don't have to tell you about the many cases that the Supreme Court has decided on the fact that competent non-attorneys can help other litigants in their efforts to access the courts. This is a well-founded principle in law, and this court's denial of our right to do this is a violation of due process. 18. We're asking this court to reconsider its interference with our access to justice. We ask for the recusal of the officer who has violated our rights to access the court. We ask for a vacating of the judgment of this court, as it was done without discretion. 19. Note we remind this court that once jurisdiction has been challenged, and in this instance it has been challenged, we retain, reserve, and exercise our right to have this body prove its jurisdiction on the record, so that the record can be properly documented. 20. Failure to prove jurisdiction on the record leaves this body in want of jurisdiction. It deprives the defendants, as well as the public, of their right to access justice. 21. The courts are always to remain open. Access to justice is supposed to be equal. If I were to quote the title of the Access to Justice Act, this body would say that that was a sovereign citizen argument. Please understand that we present no arguments before the court. This court sits in an administrative capacity, and while sitting in that capacity it is prohibited from hearing arguments, rationale, statements, or relying on its own judicial officers' opinions. That information is taken directly from the American Law Review, and the fact that I can quote that verbatim, how dare this body suggests that such is illegal and inadmissible in the courts of the United States of America, and yet this body is denying us in the public our right to access justice. 22. Does this court recognize the maxim, let justice be done though the heavens fall? Then why is it calling for the heavens to cascade in an everlasting avalanche? 23. No, this body is trying to treat us as if we don't have rights, trying to label us, trying to call us terrorists. It has placed no evidence on the record, and then it offers the opinions of judges who sit not in a judicial capacity but in an administrative capacity, as if such is binding on the people. We have mentioned to this body that we are not juristic persons as described in statute, that we are natural persons, that this body and the opposing party has brought claims against entities that are separate and apart from us in our natural capacity. 24. This body would say that the aforementioned is not true, that the parties in the name caption of this matter according to the clerk-style manual, does not represent any other party than the natural person when not specifically and severally identified as a corporation. We know this not to be true since the Supreme Court has made the collective entity doctrine a household name among corporations. 25. And as far as using case law that quote-unquote has no reference to the current matter, means that this court missed the principle about liberally construing a presentment. There were more than 45 different case laws associated with the previous objection to the recommendation presentment, and yet this body says that because the petitioners utilize a case law that appears irrelevant, this is grounds for dismissing their entire objection outright. Is that a fair assessment? Please note that this body cannot answer this question because it cannot be said to be fair as a result of its previous conduct and its previous history. 26. As we stated, we're bringing forth a claim of discrimination. This court has failed to address that and we object to this court ignoring us, but its actions prove that it is discriminating against us. It is telling us that the very same case law that was produced by officers of the court, the same officers is governed by the Administrative Office of the United States Courts, otherwise known as the O or AOU, has recognized these cases. The Supreme Court of the United States has recognized these cases, and if the Supreme Court of the United States of America has recognized these cases, this court does not have the delegation of authority to ignore them in this instance. 27. It is obvious that this court does not respect us. It is obvious that this court does not care about the rule of law. It is obvious that this court does not care about due process or equal protection of law. However, we remind this body that it does not have the authority nor the right to deny us access to justice, to due process, to the original jurisdiction of the court which is common law, and we further place our objections on the record. 28. We further remind this body and place it on notice that these are the issues that will be bringing forth an appeal. You want to call and or treat someone a sovereign citizen without a proper hearing, since somehow, somewhere, some private corporation as being the so-called sovereign citizens as terrorists, without a hearing, without due process of law, and have somehow under some authority stripped them of their rights. 29. Why, even the so-called terrorists being held at Guantanamo are recognized to retain due process rights, and yet this court is saying, because I've called you a sovereign citizen, without placing any proof on the record, such as evidence, that's all need be had, and now you have no rights, and we object to such ignorance. 30. So what? You do not like these sub-representative parties, they are interfering with your so-called processes, your hidden internal policies. They bring up that you are in direct violation of law by conducting commercial business either through the CRIS system, or other investment schemes as clearly documented in the clerical doctrine, but that somehow you think that these issues will go away. 31. You file comprehensive annual financial reports, and when taken into consideration with your references notes, term definition, and ledgers, these give every indication and documentation as well as evidence of your not operating in a lawful capacity, operating as an ordinary corporation. Please note that it is against the law for anyone to impersonate government. I believe this is what you claim to someone had done without evidence supported by unrefuted proof/fact, which makes this body a hypocrite. 32. You cannot be sovereign government, because the sovereign government pays no taxes. You cannot tax the sovereign, for it is the sovereign who issues the taxes. 33. What you don't understand is that we know that the sovereignty resides in the people, and that the people represent the national community, and that the term the people refers to a collective body. However, if one can be a member of a body, then it has already been deemed permissible for them to represent that body collectively and individually. You see, an ambassador of the United States is said to represent the United States, a military officer is said to represent the entire United States, the entire United States military, and the entire people of the United States. A police officer is said to represent the entire police force, the state for which he is employed, and the people over which he is hired to protect. So your premise that an individual who claims to be a sovereign citizen, and no one in this instance in this matter has ever claimed to be a so-called sovereign citizen, somehow can't be in at the same time by such a claim a representative of the national community that is the people, your logic is unfounded, unsupported by any hypothesis. Your logic and your argument on this matter is frivolous, nonsensical, statement made in ignorance without support of any facts and/or conclusions of law. And we object to such ignorance emphatically. 34. We are mentioning sovereign citizens, a class of people and/or persons created by the court and not law, because the comments of this court is copied and pasted from other case law of other courts which support no foundation, no proof, no evidence, just mere statements. They mention the word frivolous, meritless, but they never ever address their so-called claims of frivolousness with any law, only an opinion of some court but not with any law, and we object. Again, case law is not law, case law is actually the embodiment of ignorance of law. 35. So we come before this body, and demanding that it reconsiders its position, vacate its judgments respecting this matter, rule on the pleadings of the plaintiffs and the presentments of the defendants according to their context and not according to any misconstruing that continues to be done by officers of the administrative courts within the United States. 36. We need a decision on the issue as to jurisdiction. We need to know exactly what the jurisdiction is as prescribed by the Constitution. The Constitution spells out six jurisdictions within the United States. A judicial branch of government. 1. Original jurisdiction, i.e. common law. 2. Civil jurisdiction. 3. Criminal jurisdiction. B. Executive/administrative jurisdiction. 1. This would include the administrative courts, administrative law judges, the administrative office of the United States courts. 2. This will also include the military courts and any of the court prescribed under executive articles to the United States of America Constitution. C. Legislative or congressional jurisdiction. 1. This would include legislative courts, such as Article 4 courts, territorial courts, insular courts. 2. The United States Bankruptcy Court is a legislative court, said Williams v. the United States, 1933, for further clarification. 37. This body has made a claim that we are ignorant, that we are bringing forth some sovereign argument. You cannot have it both ways. You cannot say in one breath that one has the right to access the court, and then when they utilize the same case law that is issued by the courts to defend themselves, that they don't have the right to access the court. That's hypocrisy, that's ignorance, that is very highly prejudicial and ludicrous. 38. So either you will respond directly and specifically to our presentments, or you will be held in breach of trust. So it is at this point that we make this a formal notice to you once again, that you are a public officer, a public official, you are bound by your oath, an oath held in public trust. You are a fiduciary/trustee with a fiduciary duty of care, and we again have restated the trust and have committed this matter to binding arbitration respecting the fiduciaries who all a fiduciary care of duty to the trust. If they should fail to carry out their fiduciary duties, in the interest of the trust agreement and the beneficiaries. The statute of limitations commences to run and shall not be impeded, and the self-executing binding arbitration clause shall remain in full effect, and you shall be held liable for having breached your fiduciary care of duty, and be subject to arbitration should that deadline expire and you fail to carry out your duties as prescribed as you are under oath of office. Any actions, and/or inactions committed by you while acting under oath of office, and you are presumed to be under oath throughout every aspect of this matter, is documentation of bad behavior, and strips you of any immunity. 39. The arbitration shall be in the amount of 3 times that of the original complaint plus the amount of the cross-complaint, and since you were/are the overseeing officer of this matter, you will be held solely responsible as a result of your actions and inactions what respects the exercising of rights that are retained, reserved, preserved in the interest of the presenters. 40. It is advised strongly that you seek legal advice as to the ramifications associated with the trust agreements, your fiduciary duty of care, the rights of all parties to access the court, and your denial of access for more than 2½ years. Your obligation is coupled with interest. 41. You will document on the record and state what's best acidity what the precise, specific, and exact jurisdiction is, proof of your subject matter jurisdiction, in/and rem jurisdiction, and persona jurisdiction which is required according to statutes, regulations, rules, code, laws, and the United States of America Constitution which is supported foundationally by the Northwest Ordinance. 42. Your failure to do so will again be a breach of your fiduciary care of duty and will subject you to automatic binding arbitration. I. Failure of the court to respond to the issues presented. 43. When we do appeals we will stick to the fundamental principles, we will argue that the case was dismissed not because of the merits, but because the individual was pro se. Because the individual challenged the court's jurisdiction, because the individual brought up the fact that the courts are operating as administrative agencies during a national emergency, otherwise known as the Banking Holiday, Economic Emergency Banking Relief Act, because we have highlighted the Congress has documented on congressional record recorded in the Federal Registry making it law, that all property in the United States is owned by the United States, and that the monies of the United States shall represent a mortgage on all the homes and all the people of the United States. A. Proclamation 2039 declaring Bank Holiday March 9, 1933. B. The Federal Economic Emergency Relief Act of May 12, 1933. See Senate Report 93-549, July 24, 1973, pursuant to SRES 9, 93 DCONG, Emergency Powers Statutes, provisions of federal law now in effect delegating to the executive extraordinary authority in time of national emergency, report of the Special Committee on the Termination of the National Emergency. D. The ownership of all property is in the state, individual so-called ownership is only by virtue of the government. Senate Document Number 43, 73rd Congress, First Session. E. Reserve Act 48 STAT 337, 1934, 12 U.S.C. 411. F. Gold Reserve Act 48 STAT 337, 1934. G. Act of June 5, 1933 Act of June 5, 1933. H. The Securities Act of 1934. I. The Trust Indenture Act. J. The Servicing and Pulling Agreement. K. The Federal Housing Act. L. The Declaration of Independence. M. The Northwest Ordinance of 1787, the Act of Congress of August 7, 1789, which adopted and continued the Ordinance of 1787 and carried its provisions into execution, with some modifications, which were necessary to adapt its form of government to the new Constitution. And the Constitution of the United States. O. RESPA. P. The Fair Debt Collections Practices Act. Q. The Fair Credit Reporting Act. R. The Non-Judicial Foreclosure Act. S. The Administrative Procedures Act. T. Simple Contract Clause. U. Due Process and Equal Protection of Law. V. And the Rules of Common Law. 44. That we have highlighted that because all homes are owned by the United States by virtue of government that is through state agencies, that the real party of interest, the real party that should be sued is the United States, as they are the holder in due course as mandated by the United States Congress. However, these quasi-financial institutions cannot sue the United States as a result of the sovereign immunity clause of the Constitution and the law of nations, so they attack the people who are to have been protected by the United States since they have mortgaged all of their homes, and although their properties, and all of them. 45. We believe that this court has acted without jurisdiction, acted without discretion, for it is claimed that we do not have the right to challenge a statute is unconstitutional, after having notified the Attorney General. 46. It appears that this court is claiming that we do not have the right to bring to the attention of this court that we are in a national emergency that is continuing banking holiday, which as a direct result provides us certain protections under law, protections of which we are being denied and we object. 47. That the court's ruling did not address any of these issues, which are fundamental issues because they are backed by facts and conclusions of actual law. The court is aware that it must adhere to the intentions of Congress, and not its own mandates, policies, or agency regulations when taking into consideration a challenge to statute, and/or jurisdiction. The court's actions, specifically because they failed to address the issues presented, amongst of gatekeeping, a denial of due process, a denial of access to the fair and unbiased administration of justice. 48. According to the court, a party cannot represent an estate unless they're an attorney, so we presented a power of attorney, and instead of addressing this issue, the court simply dismissed the matter without question. Then we highlight the fact that the court charges a filing fee after the fees already collected through taxes, which covers salaries, stationery supplies, maintenance, security, and other expenses of the court according to the Administrative Office of the United States Court's Public Liaison Ms. Garcia. The charging of an additional fee amounts to double jeopardy, and we have the right to bring such a challenge, and yet the court continues to ignore us as if we do not have rights. 49. The administrative court is a farce, an actual constructive fraud, whose aim is to commit deception and fraud in the factum, because they failed to administrate justice, to render due process while providing equal protection of law. These courts, protect their officers, of which the attorneys happen to be, which creates a conflict of interest, for there is nothing in the Constitution which provides that the Attorney General's office, a member of the executive branch, can be an officer of the judicial branch of government. This is a violation of the separation of powers, a denial of access to the judicial branch of government, which leads to a denial of the right to petition for redress of grievance of the respective branch of government, which is unconstitutional/illegal. 50. The matter before this court rests on each one of these issues, and we demand that it reconsiders its level of ignorance, for it is not to consider its own opinion, its own feelings, comments, or rationale. It cannot listen to argument, for apparatus as an administrative body carrying out ministerial duties through its ministerial servants. The courts are prohibited from going against the will of the agency, which is a direct violation of adherence to the Constitution, or the courts are in place to administer justice fairly, in accordance with the Bill of Rights of the Constitution of the United States of America, and they are failing in this duty, which is a fiduciary breach of duty of care, and we object. 51. These are the issues that are before this court, and we shall not be denied our right to challenge the aforementioned, especially when this court has allowed others to bring forth the exact same challenges, yet not rise to the degree that we have brought them. And we have brought forth these challenges utilizing the actual law, statute, records of the Congress, for which this body has not brought forth any preponderance of evidence to put out the flame of get out of our way, that has caused it to violate its own oath of office. 52. The court was under oath, acting in an official capacity under the office for which they have taken an oath. They have violated their oath, which means that each of the officers participating in this farce have acted in conspiracy to deprive an American citizen of their rights, which can only amount to bad behavior during the time of office, resulting in an automatic lack of discretion, as well as jurisprudence, and we object. 53. This court is forgetting that there was a trust agreement, and a separate contract which documents the property was insured against any so-called claim of default. The mortgage insurance is in place should the borrower default. To protect the lender, we have made the claim that there has been fraud in this issue in this instance, because the opposing party has failed to notify the court of his following the tenets of the contract/trust agreement, in protecting the lender against such default that it has supplied notice of, by applying for the insurance. This is a breach of fiduciary care, and must be addressed according to the law of the trust, that is the grantor's intentions. 2. Continual attempt to convert a right to a privilege which is unconstitutional. 54. We have the right to an appeal. We have a right to have our matter heard on appeal, including the fact that we presented the Social Security Administration Form 445, the payment authorization form, which is specifically provided for covering the fees for accessing government agencies as prescribed by the Social Security Act of 1934. This court has continued to return documents, refusing to file/record, ignoring our right, instead of addressing it specifically, and we demand you will address each and every one of these points specifically with facts and conclusions of law. I.e., we demand you do your job, and yes, we can tell you what your job is because your job description is a matter of public record. 55. We object to the court having these internal policies for which the public never gets to see these so-called internal policies, including your clerk-style manual, because these policies, procedures, or deemed held secret, private. This is said to be a public agency, a government agency, and as such its policies, procedures, ordinances, rules may not be private and must be made available to the public upon demand. Are you refusing to make this information available to the public? 56. The clerk-style manual allowing your clerk to change the caption of cases, which specifically deals with legal entities, legal fictions, juristic persons, legal names, legal persons, and failing to differentiate between that legal entity and the natural person. We state that every time a person speaks in a so-called pro se status, in one of your administrative courts they are representing a legal entity, a quasi-corporation which according to your rules would require them to be an attorney. You cannot demand a party have an attorney in one instance representing a corporation and then in another instance permit them to speak pro se as if they themselves are a legal person, legal fiction, legal entity, instrumentality, a foreign estate. This court is operating and acting in total hypocrisy of the mandates for which it was established, to administer justice fairly. This is injustice, this is discrimination, this is biased, this is interfering with the access to the court, this is gatekeeping and we object. 57. When the court appears to take our statements, are attested, ascribed, declared, confirmed words, and makes it appear in our statements don't amount to anything, making the executive decision to only highlight one point or another, but never address the issues placed before it, never addressing the questions amounts to deception, attempting to conceal and we object. 58. It's one thing to set up there and say your case is dismissed because you haven't presented a controversy before the court, but to say that because you make the comment that you're a natural person, and that the caption containing the all caps name, is not a natural person, but a legal person, a legal fiction, a legal entity, and the court continues and failed to state that such has no foundation in fact or law, and then provide the facts according to the clerk-style manual which specifically specifies that all capital names in the caption is reserved only for the clerk of the court, and do not explain why this is the case by quoting from that very same style manual is disingenuous at best. This is a misleading tactic by the court to make it appear that someone has made a comment, and / or statement that has no foundation in law, despite the fact that they utilize the law when making such a comment and / or statement. 59. Then the lower court, receiving our presentments, but then demanding that we defend ourselves verbally before the court as if our presentments are to not be considered. As if our comments in court supersede our presentments and engage them. Yet the court, both the lower and appellate courts, do not do the same with attorneys. For instance, the court will hold a party speaking on their own behalf to a higher standard, making them appear to come off as if they are not legally wise, but they do not, to this very day they have not, taken a statement by an attorney and treated him the exact same way. The fact that we refer to the attorney and the masculine does not in any way suggest that we do not recognize the feminine, and yet attorneys have made some very outrageous statements over the years. No, the court and or judicial officials are about teaching and helping to educate people as to their superior stance in understanding law, and we say ignorance of the law is an excuse, for these courts are constantly telling individuals who are not attorneys that they don't understand law, so since the court is making it clear that a party who is not an attorney or a judicial officer, or other officer of the court, lacks understanding of law, then they are saying unequivocally that ignorance of the law is an excuse. B. Either it's not an excuse, and the courts have an obligation to respond to the presentments with facts and conclusions of law, or it is an excuse and the courts can't sit up on their pulpit and continue as they have been ignoring the facts, ignoring the evidence, allowing evidence to be placed on the record that is not certified, that are copies are inadmissible, and or allowing attorneys to testify on the record, when operating in their official capacity as an officer of the court. They are under oath, all the while knowing that an attorney can do not testify. So when one objects join attorney offering testimony and / or placing evidence on the record which is neither verified and / or certified and or an original which amounts to testimony, they are ignored. This is bias, this is discrimination, it is a denial of due process, which is why these courts will never ever deal with the issue of discrimination, because they're incapable of doing so because of their biased position. 3. The unlawful and illegal use of legalese. 60. The court has the habit of making statements, referring to something known as case law which amounts to nothing but an opinion of another body, but failing to provide facts or conclusions of law. Case law is not law, the lawmakers according to the Constitution can only be Congress, the court cannot make law, see, USCA 1. And we object to any and all attempts for this court in any other body administratively or otherwise to claim that their opinion is law on any level, any scale, in any arena. 61. We have the right to an appeal, we have brought forth our appeal, and you are denying us this right, which means you have converted our right to a privilege, and we object. You cannot dismiss an appeal when a party has brought forth a legitimate claim based on a so-called final judgment. To dismiss an appeal without giving specificity supported by facts and conclusions of law and not just statements which appears to be but is not in actuality law, is not a judicial determination as prescribed by the Constitution, and we object. 62. We further make a challenge to the use of legalese, legal terminology, as it is not the language of the common people. It is a language that is not readily understood by any reasonable man and or woman as required by law. The Judiciary Act of September 24, 1789 C, in particular Section 23. This is an unfair practice and its utilization creates a disadvantage, making it unconstitutional. For when you have the officers of the court, which includes the so-called attorneys, who practice and utilize a language that is unknown to the common people, this is a denial of their access to the court, a denial of their right to equal protection of law, and a denial of their right to communicate with the court in an effective and efficient way. The court has continued to use and/or utilize legal terminology when communicating with the sui juris person, the natural person, the so-called minor/infant, creating a conflict of interest and a disparagement with respects to fairness and equal access and the unbiased administration of justice, and we object. 63. We have a right to communicate with the court, to petition the court, to bring forth a grievance to the court, and yet the court has stated that our grievances must be in a format that only they get to determine, that we must state a claim according to their technicalities, instead of just mentioning what the facts are, what the situation is, so that a jury can make a determination based on the facts and evidence that's presented before them. The court uses technicalities in order to maintain its hold and control in its administrative venues, which is not supposed to be the case, but is done in this instance and all the time, and we again object. 64. We bring forth this our motion to vacate judgment, and we continue to say that once jurisdiction has been challenged it must be proved. Failure of the court to prove jurisdiction, all jurisdictional facts on the record, amounts to want of jurisdiction, which renders every decision, every notion of the court from that instance forward as complete nullities. The right to challenge jurisdiction is not a right that is left at the discretion of the court to determine who gets to and who does not get to challenge jurisdiction. 4. Certificate of Service Salutations. 65. This will no doubt prompt the court to respond with attitude, again placing itself in dishonor and violating their oath of office and the cloth for which they shroud themselves, and again we object to such unprofessionalism. Either this body reconsiders its denial of due process, access to the court, and the rights of the parties as well as the public to a fair disposition of the matter, or it shall construe this as a notice of appeal. 66. The aforementioned is presented before this body without submission and or appearance of submission under any circumstance, and it is wholly accurate on this day, so help us God. It is further certified, declared, attested that a copy of this presentment has been mailed to all parties of interest on this day by first-class postal mail, at their last known address, which is a matter of record. We wish to thank you for your time, and ask that this body reconsider its position, reconsider its failure to act with respect to our challenges. This body has taken an aggressive stance towards the presenters, a stance which is not justified. There is nothing in law which permits this body to ignore our rights. There is nothing in the Constitution which permits this body to ignore our rights, and yet by doing so this court has done the impossible. It has converted our rights to a mere privilege which it is prohibited by law from doing so. The aforementioned is attested and presented before this body as such on this July 16, 2018, is done with clean hands, without malice, without threat, without contention, and shall be conjointly construed as a statement of claim with respects to the claim against the officials who have attempted to infringe upon the rights of citizens of the United States of America, members of the general people.
He's trying to say underscore. Okay, ladies and gentlemen, let me go ahead and explain what's going on here. Of course, there are certain things that won't apply to each of you, especially the issue of an appeal if you're not doing an appeal. If you're doing a motion to reconsideration, if you appeal, you want to appeal the court's failure to hear the motion for reconsideration and motion to vacate. You focus on that, and then you focus on the issues. What are the issues? Your challenge to jurisdiction. That jurisdiction once challenged. Now, if you saw as we were going through here, I used the word pleading. I was supposed to correct that some time ago, and so now I got to resend this to the individuals. I got to redo theirs because this one is meant for the public. This one is meant for you all. This document will be placed on there, and it will be called Presentment to Vacate Decision is the name of this document. This will be placed on the SATCOM website later this day. You will just go to the download section, click the search tab, and search for this document specifically, and you will be able to have access to this access to this document. All right. Yeah, as a matter of fact, I have a member that is going to be putting up more documents, so I have to get in touch with her this day so that we'll be putting up. My hope is by the end of the month, we will have placed on the internet more than 1,000 more documents for you all to peruse. We've had people talking about how great the documents are on our website, and we're thinking that they're great too. But this has been provided for those of you who are going through the court thing and you are having your documents kicked back. The court is denying you, blocking your access. You bring up something and the court doesn't. Now, see, here's the thing. This is what the courts do. Give me a second. I need my music, y'all. So we are going to go back. Look into my eyes. You will find what you mean to me. Take me as I am. Take my life. Don't take my life. I love my life. Do not take my life. Anyway, you see, I'm using up too many resources. So I'm going to get rid of Natural Reader because I know Natural Reader is part of the problem. Be 1 second, y'all. I don't know why he wants nobody to look into his eyes. That might be blinding. Because what if he's asking the sun to look into his eyes? Okay? He probably won't be able to see for the foreseeable future. Foreseeable future. Did you see that? Did you see that? Oh, God, I am punning. Okay, I won't tell you it's not worth trying for, but really it's not worth trying for. Oh God, it ain't worth dying for. But you know it's true. Everything I do for me. I said minimize. All right, we got connectivity again. I had to get running too many things. Y'all know how I do. Okay. Ladies and gentlemen. Yeah, let's go ahead and open this. This is a document that I got off the internet. Let's get rid of all of you. I saw this document about UCC, and I'm not a fan of this junk right here. And yes, I called it junk, and I don't care if you're the person who created it. These arguments don't work. Okay? So all I can tell you is not arguments, ladies and gentlemen. I thought I would have a document here to show you how the courts have responded. Okay? But let me let you know what's happening with all of your stuff, that you're having your stuff dismissed. The court is dismissing your stuff by making statements. They'll simply say denied or stupid things like that. Get out of here. Okay, they'll denied. Ladies and gentlemen, that's not a judicial determination. Just saying denied, just ignoring your presentment, no matter how many things you bring up, is not enough. They have to give and rule dealing with facts and conclusions of law. You have to challenge their ignorance, because if you don't challenge their ignorance, then whatever they decided is law. Sorry, I need my rain meter. Okay, so what you do is you let them know, oh no, God, no, you're going to have to do better than that. See, you don't get to just make a statement and that becomes law. If you're saying I didn't do this, then you need to show me where I didn't do it, where it is not thoroughly explained in the presentment. See, they'll only take certain statements that you made in your presentment, but they won't deal with the actual argument. We had a court say that you raised two arguments on appeal. You raised this and you raised the discrimination claim. And they dealt with the other one, but didn't deal with the discrimination claim. Excuse me? Are you kidding me, right? You're going to tell me I didn't do this, but now you're not doing it. Ladies and gentlemen, as you see it, it's 10:08. And it's Saturday, the 21st of July. I have to finish the TRO. I was going to send in a TRO a certain way, and then I realized, wait a minute, you can't send that TRO in that way. you have to send the TRO in this way. So now I got to redo the TRO, but I like the way I'm going to redo the TRO because of that presentment motion that I just showed you. That helped me to rethink on how to do the TRO. Oh, beep, 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 beep. So I want to thank you guys for taking the time. Now, before we conclude this, we're going to play one more song, and I'm going to explain something to you, the program that I was telling you that we were going to be bringing to SACCOM. Ladies and gentlemen, we're going to be bringing a program, and it's going to simply be called, let's just say, we haven't given it a name, so let's just call it the TR program for Tony Reese. No, sorry. There's a young man who watches my videos. His name is Tony Reese. But there's a young man I grew up with. His name was Tony Reese. I haven't spoke to Tony in over 25 years. But TR, not Tony Reese, but in memory of my friend Tony, the one I went to junior high school with. He's an alright young man. He was unique, but he was not loyal to say any sense of the word. That's what I perceived in him the whole time I knew him. So I pretty much kept him at a distance, but Tony was allowed to hang around me. Plus Tony was about 5'3", and so he hung around me so nobody would pick on him. And he doesn't think I know that. I promise you, to this day, he doesn't think that I know that he hung around me because nobody would mess with him if he was around me. Because Tony and all my friends know that, well, everybody at school knew that you didn't get to touch my friends. You touched my friends, you had to deal with me. And so I had many of friends. Promise you, I had many of friends. As a matter of fact, I would walk down the hallway at one particular school and everybody would be shouting my name. Now, it wasn't I thrived off of that, but I liked the fact that everybody knew me and respected me. And they did. Everybody, just like today, people know me, respect me. They may not like me, but they respect me. Well, one of the school teachers actually went around asking people about me because he was hearing about me. And he wasn't hearing about me by name, he was hearing about me by the bull. Who is this bull character they keep talking about is what he was asking the teachers and the students. He thought I had too much power. And so he eventually kicked me out of the school for nothing. He thought I had too much power. And mind you, let me explain. I wasn't the type of guy who was hurting people, fighting people, getting in trouble, causing people to do wrong things. Literally, I just made sure that if you were going to have a fight, if you were going to cause problems, it had to be fair, it had to be done a certain way. And if this person knew me and you fought this person, then you would have to deal with me. Ladies and gentlemen, very few fights in the school. As a matter of fact, everybody was literally talking about those years. I'm not going to tell you the school. But I promise you, I broke my neck to go to that particular school because of where it was, and everybody else was talking about it before I got there. But when I got there, I promise you, when I hit the 12th grade, it was a much better year. The 11th grade was okay, but the 12th grade, and like I said, I only had to go to school for first, second, third period, and then after that, I went to work because I'd already had all my credits. See, unlike many of you, I went to summer school purposely. By going to summer school, I got the credits. That's what you're looking for, just like in college. You take those programs you don't need to take just so you can get the credits. Well, most people will go and take care of their credits first. Well, that's what we were doing. So my mother had us go to summer school. At first, I don't want to go, dummy too. I want to be all dummy like everybody else. I want to be. Shut up. You're going to summer school. So I went to summer school, and it turned out to be a benefit. Because like I told everybody, I went to school, and it turned out in the 11th grade, I got to go home at lunch. In the 12th grade, I got to go home at nutrition. Okay, but I didn't go home. I went to work. Okay, so anyway, let's get back to this breakdown of the understanding. Oh, you guys know this song, don't y'all? It was the 3rd of September. that day I'll always remember. That was the day that my daddy died. It was actually the 5th of July. Okay, this is the Papa was a rolling stone head, yeah. All right, ladies and gentlemen, the program that we're going to be starting, I called up one of my SATCOM members, and I told him it should be a sin, it should be illegal, it should be against the law for somebody to be this much of a genius and be allowed to exist. I said Stephen Hawkins was nowhere near my level. Oh my God, there he go talking like that again, like he all that. Ladies and gentlemen, I can't tell you the idea because I gave it to SATCOM. And I wish I could. But I told him I was giving it to SATCOM in conversation. Once I did that and I called SATCOM and told him, I can't tell you. If I had done the video when I said I was going to do the video, then it would have been yours. But sorry, you're not grandfathered in. I ended up giving that to SATCOM because I realized how beneficial it would be. But what we're going to be doing is we're going to be starting we'll call it the TR program, where we're going to help people. There are a couple of proceedings that they'll have to go through, but these proceedings are designed to stop foreclosures. We'll be looking for people who have just got their notice of default. I know that doesn't help. Well, this program could help the people who've already received their notice of default, but it will take a lot more, and we don't have the resources for that. No, I'm not telling you right now. Okay, so we'll be helping the people who just received their notice of default. This will not be filing no bankruptcy. You'll still have all of those other options that you've heard people talk about. Those other options will still be on the table. But this one is a simple filing. Okay? The only problem is you're going to find that this will be more beneficial for the people whose mortgage payments are $2,000, $3,000 a month, because that's how much it will cost for you to do the beginning of this process. But when you do this, during the whole time the process is going, you won't have to pay a single dime to the creditor, to the so-called lender, to the so-called service company. By law, there will be an automatic stay, and it's not bankruptcy. Okay, and this is a legal proceeding that is recognized in all the courts. In some states, you don't even have to go to court to do this. Now, mind you, other people will find out about this and they will make a business out of it and they'll try to do the same thing. Ladies and gentlemen, they won't be able to do the same thing because they won't understand the angle. See, even if they thought they knew, it's okay. We don't care. But I can't tell it to you because, sorry, I gave it to SATCOM. All right, look, I'm going to have to let you guys go because I got to go and amend those documents. I got to work on the TRO, redo the TRO, which took me 5 days to do. I got to redo it, but I know how I'm going to redo it, and then we're going to get that filed into the court. Oh, by the way, let me let you all know because you guys need to know this. We got our common law lawsuit filed in the Superior Court in California. Okay? Now, don't know what they're going to do with it, but I promise you I'm not letting it go. Y'all know me, Pitbull. The Defrauded Homeowners of America, you guys will have a video update coming soon. Okay? Stay tuned, everyone. I hope everything continues to go well with all of you. I want to thank you for taking the time and ask that all of you have a very good day. Goodbye. Good night. Good afternoon. Good morning. Good everything. You know, I just have to play this part right here. And mama,